Welcome to the deep dive. Our mission today. Well, it's about swift, efficient knowledge transfer on a really pivotal piece of legislation. The Small Claims Courts Act 61 of 1984.
That's right.
For anyone really needing to understand how rapid, accessible justice works in South Africa, this deep dive is your shortcut. We want to help you master the system.
Yeah, we're looking at an act specifically designed to simplify justice for the everyday person. It provides a channel for the adjudication of small civil claims.
Okay.
So we'll look at the architecture of these courts, their limits, and their surprisingly unique procedures. It's all built on deliberate trade-offs, really, aiming for speed and affordability.
And we've got the complete framework, right? Including the latest details, rules updated just this year. So if you're a law student comparing this to, say, the magistrates court, or just someone curious about settling a small dispute without, hiring a lawyer.
Then this is for you.
Exactly.
Yeah.
This session unpacks the core purpose, the key provisions, and the practical side of this crucial law.
And specifically, I think we need to nail down three main things. The court's unique status, that revolutionary inquisitorial procedure, and the hard limits on jurisdiction.
Right.
That tells us exactly what problems this court is meant to solve, and maybe more importantly, which ones it's explicitly designed not to solve.
Okay, let's unpack this. Starting with the basics, the why and how these courts even came about. The act got assent back in April '84, but it only kicked off later, August 24th, 1985.
Yeah, bit of a delay there.
And the goal, right there in the title, seems pretty simple. Courts for adjudicating small civil claims.
It is straightforward. And the setup process under Section 2 is very top-down. The Minister of Justice and Constitutional Development establishes them.
How? Just decides.
Well, they issue a notice in the Gazette, the official government publication, and that defines the court for a specific geographical area, like a district or even part of one.
So it allows the government to kind of roll out justice where it's needed most, perhaps.
Exactly. Tailored to regional needs, incrementally. Now, here's where it really starts to look different from your standard court. Section 3. This is crucial.
Okay.
The general rule. A small claims court shall not be a court of record.
Not a court of record. That sounds technical, but what does it actually mean in practice?
It's fundamental to ensuring speed. Think about a high court case. Everything said is transcribed word for word by a stenographer. That creates a massive record.
Right, which can lead to huge delays, arguing over procedural points caught in the transcript.
Precisely. This provision cuts out that complexity, that bulk. No verbatim transcript of the whole proceeding.
But hang on, the decision itself is still official, right? It's binding?
Oh, absolutely. The presiding officer, the commissioner, must record and sign the final verdict, judgment, or order. That gets logged. It's enforceable.
Okay.
And importantly, any process from this court, a summons, an order has legal force across the entire republic. It underlines its legitimacy, even with the simplified structure.
And that accessibility seems reflected in how they operate, too. Like, proceedings are generally open to the public.
Generally, yes. Though the court can decide to close doors, in the interest of the administration of justice, or of good order, or of public morals, fairly standard stuff.
And language.
Flexible. Either official language can be used. If someone isn't fluent in the language being used for evidence, an interpreter can be called. It's about making sure people can participate.
Okay, now Section 7. You mentioned unique procedures. This feels like a big one. Who can actually use this court?
This is maybe the defining characteristic. It shapes the court's whole spirit. Only a natural person, basically, an individual human being, can start an action as a plaintiff.
A natural person. So, me as an individual, yes. But what if I run a small company? Can my company sue someone here?
No. That's the key. A juristic person, a company, a corporation, any legal entity that isn't a human can only be involved as a defendant. They can be sued here, but they can't initiate the lawsuit.
Wow. So it's really designed as a tool for individuals.
You can see it that way. A shield for the individual facing a smaller claim, perhaps, rather than a tool for businesses chasing debts efficiently.
And tied into that accessibility idea, the famous no lawyers rule.
Ah, yes. Section 7 again. A party has to appear in person, and generally they cannot be represented by anyone else. So no lawyers for the plaintiff or for an individual defendant.
That's a huge difference.
It's the biggest trade-off, arguably. You save potentially a lot of money and time on legal fees, but you lose the benefit of having an expert navigate the legal side for you.
Is there any exception? What about that company being sued?
That's the one main exception for representation. If the defendant is a juristic person, the company, it has to be represented, but by its duly nominated director or officer, not an external lawyer.
Okay, so if you can't bring a lawyer, the person actually running the show, the commissioner, they must be incredibly important. Let's talk about them, the guides and the rules.
Absolutely. The presiding officer is called a commissioner for small claims, and the Act, specifically Section 9, puts a real emphasis on their qualifications. And that makes sense, right? Because they carry so much weight in this simplified process.
How qualified do they need to be? I mean, it's small claims.
Don't let the name fool you. The standards are high. They need to be qualified as an advocate, an attorney, or even a magistrate.
Okay.
And crucially, they need to have practiced law, or maybe tutored law, for an uninterrupted stretch of at least 5 years, or have other suitable experience.
So real legal grounding. It's like they're compensating for the fact the parties don't have lawyers.
That's exactly the idea. Streamlined justice, yes, but administered by someone who genuinely knows the law.
And there's a point here about neutrality, isn't there? Section 9(1).
Yes, a really important insight. The Act explicitly says an officer employed by the state cannot be appointed as a commissioner.
Why is that significant?
It ensures a separation. You don't have, say, a government administrator moonlighting as a judge in these cases. It bolsters judicial independence, which is vital for fairness.
And speaking of fairness, they take an oath, right?
They do. They have to swear or affirm to administer justice to all persons alike without fear, favor, or prejudice. That commitment is crucial, especially given the procedural differences we're about to dive into.
Yes. The procedure. This is where the small claims court really carves its own path, isn't it? The inquisitorial system in Section 26.
This is probably the single biggest procedural shift. Anyone studying law needs to highlight this. The formal rules of the law of evidence, they just don't apply.
Don't apply at all. So things like hearsay.
Gone. Rules about privileged communication set aside. The Act says the court can ascertain any relevant fact as it sees fit.
Wow. So the commissioner isn't just a referee between two sides. They're more like an investigator.
Exactly. That's the core of the inquisitorial approach here. The parties themselves do not cross-examine each other or any witnesses.
No cross-examination.
None. Instead, the commissioner takes charge. They proceed inquisitorially. They ask the questions. They probe the facts. They can question parties or witnesses whenever they think it's necessary.
Can you paint a quick picture? What would that look like in a hearing?
Okay, imagine a simple dispute. Maybe someone hired a contractor to build a small fence and it fell over.
Right.
In a regular court, you'd have lawyers presenting evidence, maybe expert reports, lengthy cross-examination. It could take days.
Okay.
In the SEC, the commissioner might listen briefly, then perhaps interrupt and say to the homeowner, okay, show me the photos. Where exactly did it break? Then turn to the contractor. What type of wood did you use? How deep did you set that post? They actively dig for the facts themselves.
Much more direct.
Very direct, very active. Judicial investigation, you could call it.
And this simplification extends to starting the claim, too. You can't just jump straight to court.
No, there's a built-in cooling off or resolution step. Section 29 mandates it. The plaintiff must first deliver a written demand to the defendant.
Like a letter saying, you owe me money, please pay.
Essentially, yes. And they have to give the defendant at least 14 days to sort it out, to satisfy the claim, before they can even issue a summons to go to court.
Encouraging people to settle first.
Exactly. Pre-litigation resolution is baked in. And then, even when you do issue the summons, the paperwork is minimal. Apart from that initial summons, generally no formal pleadings are required.
No complex legal documents back and forth?
Nope. The defendant can choose to file a written statement outlining their defense, but it's not mandatory, like in higher courts.
Right. Let's talk jurisdiction then, the practical limits. What cases can this court actually hear?
Okay. Section 14 lays out the basics. The court has jurisdiction if the person being sued resides in its area or carries on business there or is employed there.
Yeah.
Or if the reason for the lawsuit, the cause of action, rose entirely within that court's geographical area.
And what kinds of claims?
Right.
Section 15, right?
Yes. It covers a fair bit, but it's specific. Things like actions for the delivery or transfer of property, ejectment, getting someone off property claims based on liquid documents.
Liquid documents, like an IOU.
Sort of. Think documents that clearly show an undisputed debt, like a check that bounced or an acknowledgement of debt. Also, claims under credit agreements and just general claims for payment of money.
But there's always a catch, isn't there? The money limit.
The big one. That's what really defines a small claim.
Yeah.
All those types of actions are subject to a monetary limit.
And who sets that limit?
The minister sets it and updates it now and then by putting a notice in the Gazette.
So it's not fixed in the act itself. It can be adjusted for inflation, presumably.
That's the idea. It allows the limit to keep pace, theoretically, without needing to amend the act constantly. But it also means the court is always restricted to, well, genuinely small financial disputes, whatever small means at the time, according to the minister.
What if the whole history between two people involves a lot more money, say our $50,000 in total dealings, but the specific thing being sued over now is only our $15,000, which is within the limit? Can the court look at the bigger picture?
Yes, it can. That's covered by Section 17, incidental jurisdiction. The court can inquire into the whole account, even if some items exceed the limit, as long as the actual amount being claimed in the lawsuit is within the jurisdiction.
Okay. So you can't just say, oh, our total business was too big to avoid the SEC if the current claim is small enough.
Exactly. It prevents that kind of defense.
Now, you mentioned earlier what the court can't do. This is where it gets really interesting, right? The absolute no-go zones in Sections 14 and 16, these seem to define the court's boundaries, maybe even politically and emotionally.
Very much so. Limitation 1 in Section 14 is clear. You cannot sue the state in the small claims court. Suing the government usually involves complex administrative law, maybe constitutional points. It's just not suited for this super simplified fast-track process. Section 14 also says no claims based on cession or assignment of rights. Basically, you can't sue on behalf of someone else who transferred their claim to you.
Okay, no suing the government. What else is off limits? Section 16 has a list, right?
It does, and it's mostly about areas that are legally complex or involve personal status and high emotions. The court has no jurisdiction over divorce or the dissolution of customary unions.
Makes sense.
Nor can it rule on the validity or interpretation of a will or testamentary document, or determine someone's legal status regarding mental capacity. These are all matters for higher courts with more formal procedures.
What about forcing someone to do something rather than just pay money? Specific performance.
Generally, no. The SEC can't order specific performance unless it's one of two specific things. Ordering someone to provide a detailed account, like financial records, or ordering the delivery or transfer of property, but only if the value of that property is within the monetary limit of the court.
So, limited exceptions there.
Very limited. And then there's a whole category of damages claims the court just won't touch. These are usually subjective, harder to quantify harms.
Like what?
No claims for defamation, damage to reputation, no malicious prosecution, wrongful imprisonment or arrest claims, no seduction claims or claims for breach of promise to marry.
So things involving personal character, emotional harm, the SEC stays away.
Exactly. It needs to stick to more tangible, straightforward disputes about money or property. It also cannot grant an interdict that's a court order telling someone to stop doing something or compelling them to do something. That requires a higher level of scrutiny.
So what happens if a case starts simple but then turns out to be really complicated? Is there an escape hatch?
Yes, absolutely vital. Section 23 provides a safety valve. If the commissioner looks at a case and finds it involves difficult or complex questions of law or a fact that the SEC just can't adequately or fairly handle,
In what?
then the commissioner must stop the proceedings right there. The plaintiff isn't penalized. They're specifically allowed to start a fresh case in a higher court, like the magistrates court. The system recognizes its own limitations.
Okay, fast forward. The case has been heard. What about the end result? Judgment? Getting paid? And how final is it all? Section 34 talks about judgments.
Right. The outcomes are fairly standard. Judgment for the plaintiff if they prove their claim, judgment for the defendant if they prove their defense or a counterclaim, or absolution from the instance.
Absolution from the instance. That sounds quite formal. For the average person, what is that?
It basically means the court is saying, look, based on the evidence presented here today, I can't definitively decide this one way or the other.
So, not a win for the defendant.
Not exactly. It leaves the door open. The plaintiff isn't barred from trying again later if, maybe, they find stronger evidence. It's different from a judgment against the plaintiff.
Got it. Now, a big part of the SEC's appeal is meant to be affordability. How does the Act handle costs? Section 37.
This is key to the accessibility goal. Costs that can be recovered are strictly limited. You can only claim back basic court fees, a small prescribed amount for actually issuing the summons, and the fees and travel expenses for the sheriff or messenger of the court who serves documents.
And that's it. No lawyer's fees, obviously, because there aren't any. but no costs for preparing your case either.
Correct. No recovery for your time, your preparation, expert reports you might have gotten yourself. It keeps the financial stakes very low. That's probably the single biggest tool ensuring affordability.
What if the defendant just doesn't show up?
The court can grant default judgment under Section 35. But the plaintiff still has to quickly prove the defendant is liable and the amount claimed is correct. It's not automatic.
Okay, so let's say the plaintiff wins. How do they get their money?
Section 38 is clear. The money must be paid directly to the judgment creditor, the person who won. No going through court accounts usually.
And if the debtor says, I can't pay it all right now?
The court doesn't just give up. Section 39 allows the court to conduct an inquiry into the debtor's financial situation. This happens in camera, meaning in private, not open court.
Why private?
To protect the debtor's financial privacy, usually. Based on that inquiry, the court can then make an order for payment in specific installments that the debtor can realistically manage.
And there's even a rule about moving house.
Yes, interestingly, under Section 4347, if a judgment debtor fails to notify the creditor of a change of address within 14 days, it's actually an offense. They could face a fine or even imprisonment. Shows they take enforcement seriously.
But wait, does the small claims court itself have bailiffs who can come seize property if someone still doesn't pay?
No, that's a crucial distinction. The SEC doesn't have its own enforcement arm like that.
So how does the winner actually get their property or money if the loser refuses to cooperate after an installment order?
Good question. If the payment fails, the SEC judgment becomes enforceable through the magistrate's court that has jurisdiction in that area. That's Section 41.
So you have to take your SEC judgment to another court?
Essentially, yes. The SEC clerk helps. They transfer the judgment order and an affidavit confirming non-payment to the relevant magistrate's court. Then the standard execution procedures of the magistrate's court, like potentially attaching assets, kick in.
Okay, that makes sense. Now, the really big question, tying back to those trade-offs, finality. What if someone thinks the commissioner got it completely wrong? Can they appeal?
This is perhaps the most stark feature of the SEC. Section 45 lays it down unequivocally. A judgment or order of a small claims court shall be final, and no appeal shall lie from it.
No appeal.
At all. None. That's the deal. You trade away the right to appeal for the speed, the low cost, and the simplified procedure. If you use the SEC, you accept the outcome as almost certainly the end of the road.
Almost certainly. So there is some recourse.
A very, very limited one. Your only potential avenue is not appeal, but review under Section 46. And the grounds for review are incredibly narrow.
How narrow?
Review isn't about arguing the commissioner misinterpreted the facts or misapplied the law on the merits. It's about fundamental flaws in the process or the commissioner's conduct.
Such as?
The grounds are basically absence of jurisdiction. The court shouldn't have heard the case at all. Clear evidence of interest, bias, malice, or corruption on the part of the commissioner, or what the Act calls gross irregularity with regard to the proceedings.
Gross irregularity, like?
Maybe refusing to hear relevant evidence you try to present, or basing the decision on something completely outside the case. It has to be a major procedural failure, something that fundamentally undermines the fairness of the hearing itself, not just disagreeing with the conclusion.
So challenging the process, not the substance of the decision.
Precisely. It's a very high bar to meet.
Right. So let's try and pull this all together. What's the big picture here? We've seen the small claims court is, well, deliberately streamlined. No lawyers for plaintiffs.
Relaxed evidence rules.
An inquisitorial commissioner taking charge.
Extremely low costs.
It really is a purpose-built fast lane, isn't it? Designed specifically for resolving relatively minor disputes quickly and, importantly, affordably.
That's the core philosophy. Accessibility and finality. By sacrificing a lot of the legal formality, banning lawyers for individuals, ditching the traditional adversarial process, the Act aims for mass access to justice for small problems.
And for someone listening, maybe a law student or just someone facing a small claim, what's the key takeaway?
I think it's recognizing that the small claims court operates on a completely different set of principles compared to, say, the magistrate's court. It prioritizes getting a resolution quickly and cheaply, potentially overachieving perfect legal exactitude in every single case.
That tension makes sense, yeah. Speed versus maybe absolute correctness.
It's a policy choice reflected in the structure.
Okay, before we wrap up, here's something to maybe chew on. A final provocative thought for you, our listener. We've seen the SEC's effectiveness really hinges on that line between a small claim and a complex one, largely defined by that monetary limit. Now, that limit is currently set just by the minister putting a notice out. Should it stay that way? Purely discretionary. Or should the act maybe be changed to automatically tie that limit to a standard economic indicator, perhaps inflation, to ensure the court genuinely stays effective for truly small claims as costs rise over the long term? Something to think about.